Good afternoon, everyone. You're here attending the information session for self-represented litigants. Just before we start, I'd like to explain that this information session is to provide general information to you, and that I'm not here to provide you with legal advice today, but to provide you with legal information that's going to assist, just so that you know that advice is specific to your particular rights in your particular process. And today I'm just providing you with general information. My name is Margot Pomerleau. I'm from NBC Law, but I'm going to be providing you with information about my experience over the last 10 years or so in small claims court, and some tips about representing yourself, attending in court, being able to present your case. I'm a civil litigator, so I practice in the area of commercial litigation, estates, contract, neighbor, property disputes, and I'm happy to share my experiences with you today. The purpose of the information session is to introduce you to this information. First, we give thanks to the Ottawa Community Foundation for its support, and as well AJEFO for setting this program up. Now, let's begin about talking about the judicial system generally. What I'm going to do is talk to you about the different roles, how they play in small claims court, how it is that you are to address those individuals, and how they act in your case, and how to be able to pursue your case better that way. So of course, the judge being an important person in your case, somewhat of an arbiter, but is responsible for making independent, impartial decisions on the issues between the parties. Does this by interpreting the law, of course, applying the facts and decisions from other cases, taking those decisions from other Canadian courts, and that could be the Supreme Court, Court of Appeal, other small claims decisions as well, and making sure that everybody's, all the parties and the witnesses' rights are being respected while the process is going forward, and making those decisions so that everybody can be properly heard as the court system allows them to be. In small claims court, you have a deputy judge. A deputy judge is a person appointed as a deputy justice to the small claims court. They are lawyers, and they're appointed, and they often still practice in private practice as well as sitting as deputy judges. Some of them work full-time as deputy judges, but it is possible that you have somebody who practices at the same time as being appointed as a deputy judge. Now, there's many court services officers that maybe you have experience with dealing, and they're also responsible for the proper conduct of the proceedings in court. Of course, the officer's primary duty is to assist with the presiding judge. So having witnesses attend, being able to have the witnesses in the room, excluding parties from the room if necessary, being able to assist with the flow of the courtroom with information and people going in and out. A court clerk is also somebody that you may have seen in small claims court. They ensure that the actions by the parties are coordinated and carried out at the right time. The clerk plans hearings, announces the court rules as you come into court, make sure that everyone's aware of particular rules and etiquette, a big one being turning off cell phones. We're not allowed to have cell phones on while we're in court, very important. Often people take that for granted. It's not just for the presiding and to make sure that your phone doesn't go off while you're presenting evidence, but also so that people are paying attention out of respect and respecting the court procedure as it is. You're not allowed to bring food or beverages into the courtroom. You can drink water, but the court clerk is responsible for maintaining all of those aspects. You shouldn't be wearing a hat unless it's for religious purposes either. Chewing gum in a courtroom, also frowned upon. We're trying to keep this aspect of decorum while you're before a judge or in the court, so that you can be judged on the merits and the facts of your case, and not about the way that it's being presented. And the court clerk, part of their role is to be able to ensure that that happens. The clerk is also the person who administers the oaths and direct witnesses to swear or affirm to tell the truth as well. So also a very important role in, again, administering how information and evidence is presented in the court. There's a court reporter. And a court reporter records what's said during the hearing. So while the judge is in session, while the hearing is in progress, either some motions and certainly during trials, the evidence is being recorded, and what you're saying is also being recorded. It's important to understand that while you're sitting at what we call counsel table and sitting at that table, that you are mic'd and that what you are saying is being recorded. And even though it's not being said on evidence, you need to pay attention that it's possible that it gets passed over to those people who are going to be transcribing. And you have to understand that everything that you say while you're in court and in evidence is transcribed and is put in on a transcript for the hearing and by the court reporter. Other parties, of course, and players and roles in the small claims court are the actual parties to the action. So a plaintiff is the person who institutes the action. So it's possible that you're in a small claims action representing yourself because you're a defendant, and therefore this claim has been issued by another party, and that person is the plaintiff. It's a plaintiff's claim that starts that process, as you may or may not know in small claims court. The defendant is the person that receives that against the with whom the action is brought. There might be more than one plaintiff, there might be more than one defendant as well. And the plaintiff's claim, the response to that is a defense. And the defendant is that person who's defending their rights and replies to the plaintiff's claim. You may also be involved in a matter where there's a lawyer in there, so a part of that process. The lawyer represents one client and one client's perspective, or various clients, either multiple plaintiffs or multiple defendants, and the lawyer negotiates on behalf of that client, represents and attends at hearings on behalf of that party and is the voice of that party. Possibly argues a motion or argues a trial or simply presents evidence, and they're the voice of that party, and you should be dealing with them as if you were dealing with that party directly. It's very rare that a party who's represented speaks or communicates directly with you, either in court if they have a lawyer or they have a paralegal. It's important that you direct your inquiries and your communications to that paralegal, that representative, or that lawyer instead of communicating directly with the party. Of course, the judge and court employees are neutral parties at a hearing, to understand how those rules kind of fit in, and that they're not there to give you legal advice. They can't tell you whether you're going to win or whether you're going to lose, or what we call certain merits of the case or how things are going. And court employees aren't there to give you opinions about the progress of a hearing, either on how long things are going to take. But that being said, they are a party to this whole system, and they can provide you with information and are often open to providing you with information about court procedures, about locations at different courtrooms, or how certain things work. And so they are neutral parties that are there to make things go forward. While you're attending in court, and if you would like to have a family member or a friend be present to support you, you can ask for a special permission, and a judge can allow that depending on the circumstances. Without prejudice hearings, so a settlement conference, for example, it's necessary for you to have permission ahead of time. It's necessary for you to have permission from the parties and to give notice of the parties. But when we're talking about a motion or we're talking about trial, these are public hearings. And so somebody can be there and be able to attend with you because it's a public hearing, and they have a right to be there as a citizen just as much as they are a right to be there to support you. It's also very important for you to understand that you cannot record any hearings, and you cannot use your telephone to be able to record a hearing or a motion or what a judge is saying, and you're precluded from doing so. Let's talk a little bit about the rules. You may be familiar, if you're partway through litigation at this time, you may be familiar with the fact that there are rules of the court. And you have to be, as a self-represented litigant, familiar with the rules and how to use them. You're entitled to be heard and you're entitled to present your case. And you're not expected to know all of the rules as if you were a lawyer and went to law school, but you should understand the operation of them and should understand how to present your case and how to use them. I certainly recommend that you read the rules. If you were going to attend a motion, for example, there's particular rules that are just about motions, and just to read those rules. Also, there are some public guides out there, and I have some links for you here, but they'll be in the resources later on. Certainly read the guides and the ministry has put together and the Attorney General to be able to read through on what to expect and the process of that. The rules are there to protect you, but they're also there for you to be able to show your case. Use those rules. It's possible for you to present evidence a certain way, or to have a certain right, or to be able to push on the next step. And those rules aren't there to block you. They're there so that you can pursue your case. And so you should be familiar with those. Now, aside from the rules, there's also the concept of etiquette and what rules to follow, those etiquette rules to follow. Formality, civility, they're fundamental values to our justice system. It's really essential to show some respect for that system, to be able to be consistent at all times when you're in court on being courteous, on this formality and this civility. Anything less than that really demonstrates a lack of respect for how that administration of justice is delivered. We're very lucky on the system that we have, and its proper operation is assisted by those who respect that while they're in there. It's important to follow some general practices, and these are some of the tips that I have for you to keep in mind while you're at a hearing that are going to assist you in delivering your case and being convincing because of the way that you are going to respect that etiquette and respect that system. First, how you look. You should dress in a business casual clothing. You shouldn't wear a hat or head coverings or anything to cover your face or your head unless it's for religious reasons or for safety reasons, of course. I certainly don't wear any sunglasses or to cover anything like that. I also would recommend not wearing clothing with words or images that might offend either some of the court staff or the judge, of course, who's going to be making a decision. I think that these are aspects on being able to deliver your message in a convincing way, is to not have anything distracting. Be on time. Being on time and being a little early is recommended. You don't want to be rushed, of course, for your own way to present your case, but also you don't want the court or the judge waiting on you. Address the judge when you're in the courtroom as Your Honor. And continuously do so, sometimes even just having a post-it note beside you and being able to remember how to address certain parties if it's lawyers on the other side or the judge. During the hearing, only address the witness or judge when asked to do so. Everybody has their turn to present and to be able to speak. And so wait for your turn, and certainly don't interrupt a judge, and certainly don't interrupt a witness, or don't interrupt a party on the other side, a paralegal or a lawyer. Ask questions and make submissions when it's your turn, because you'll have that turn. So don't worry about missing out on something. Of course, the only legitimate exception to that is an objection when you're in trial and a question is asked and you don't think it's an appropriate question. You're allowed to stand up and to ask that question not be allowed. If you want to object, you stand. If you want to speak, you stand. If you want to have the court's attention, you stand. And so when making an objection, the question is being posed, you stand up, the judge will look at you, and then you state your objection. There are no objections to submissions or argument, either opening submissions or closing submissions. You have a right to reply to that. You will have your turn, or you've already had your turn. And so it's not appropriate and certainly frowned upon to interrupt submissions. Something to note as well is always address the judge if the judge is in the room. You shouldn't be communicating to another lawyer or the other party or directly with another paralegal while the judge is in the room. You speak to the judge. You ask questions of the judge. You speak to the judge questions to the witness, being able to pose questions to the witness. You do not speak to the other party while the hearing is in session. Of course, rules of etiquette and civility when the court is not in session to be cordial and good morning, good afternoon, and you can speak to them while that is going on, of course. Don't chew gum, don't eat. You can, of course, drink water during a hearing. Of course, limiting vulgar language, inappropriate language, swearing, certainly frowned upon it, and I wouldn't suggest that. If things are being frustrated and things are getting heated, emotional, take notes of things. Being able to note them down, noting that that happened is often a good outlet to be able to remember that something happened, but not having an emotional response to that. Nowadays, and because of the health crisis, it's highly unlikely that your audience is even going to be heard. It's more likely it's going to be heard virtually than in person. So here are some just tips about virtual attendance, similar to what we're doing today. Make sure that you test your microphone and your camera before, maybe even testing it with another person, a neighbor, a friend, a family member, just to make sure that you're familiar with that. Make sure they're working. Make sure that the device you're using is able to join the meetings, update your software. Often there's delays because, oh, you checked it maybe a week ago, but this is the first time that you turn that computer or that software. There's delays. It'll affect the timing. Again, what I recommended on being on time, even being early for a court appearance. And even if it's by telephone or by video conference, making sure that you're familiar with that and how things change and how updates change is very important. Sit in a place with a neutral background or face a source of natural light as well, so that they can see you and that it's not something too distracting in the background. And when you're not speaking, to keep your microphone on mute when you're not going to be speaking because of the ambient noise. And it's also out of a rule of etiquette now that we're following on keeping mics muted when you're not speaking. Now, let's talk a little bit about steps in the case and how that might affect how you represent yourself in court. And so a little bit of the differences between a motion, a pretrial, trials, and how that works. Let me talk about that a little bit. So a plaintiff's claim is that document that starts the litigation, and it's filed by a plaintiff in the small claims court. Now, the person who is served with that document, the person who receives that, the defendant, then drafts, serves, gives, and files this statement of defense, the defense to the plaintiff's claim. After the defense has been filed with the court, then the next step is the settlement conference. A settlement conference is a court hearing. It's a without prejudice off the record hearing, but it is a court hearing. It is before a deputy justice, but it's a private meeting. It's between the parties, so the plaintiffs, the defendants, and the judge themselves, possibly paralegals or legal representatives like lawyers as well. The purpose of the meeting is to see, first of all, if the parties can resolve one or all of the issues. It's a settlement conference. You're trying to reach a settlement or narrow the issues. Maybe of the 5 things that somebody is pursuing, that 2 of those things can be resolved. It's also the opportunity to disclose the evidence. There's timelines with respect to filing information, serving information, and preparing the case for trial. It's possible to get orders at a settlement conference. It's possible that the judge orders certain documents be disclosed, certain will say statements, maybe summaries of evidence, and maybe the exchange of other type of information, maybe photographs, and timelines to be set. And like we'll speak a little bit later, maybe a bilingual proceeding or interpretation needs that need to happen. Settlement conference is the time to decide that, and the court may order that. Now, on a motion, a request is being made to the court by one party to the other parties to have something done or to resolve a dispute that's limiting the action going forward. It's also possible that everybody agrees to the motion. Sometimes a document needs to be disclosed or a step needs to happen. Maybe you need a second settlement conference. It's an ask. A motion is you're asking the court to do something. A motion can be done at any time. It can be done prior to the settlement conference, after the settlement conference, before trial, at the trial, during the trial. Asking for a document disclosure is a good example of you're moving your case forward. You need a possible document, and that document is being held by another party who says, well, it's not relevant, I'm not giving you that document. And so you bring a motion to the court to ask the court to order for that document to be delivered. So motions are a way for you to obtain that relief, to be able to ask something and get an order for somebody to do it. Trial, of course, is a request for the matter to be heard before a judge, for a judge to hear all of the evidence and to be able to hear the witnesses, to read the documents, to see the documents, and then to be able to render a decision based on those facts and how that applies to the law. There's also an assessment of damages. It's kind of a mini trial when a plaintiff needs to have a judgment, a decision by the court, but there's nobody opposing it. And so it's an assessment hearing. It's conducted like a trial where the plaintiff presents their evidence and shows their documents, but there isn't an opposition to that. And then the judge bases his decision on the facts being presented. Now, a couple of tips on preparing for trial. I'm recommending first that you review the rules and the guide for that hearing and that particular process, if it's an assessment hearing or a trial. Even I do that before I go to court, and certainly recommend people in our office just be familiar with the rules, know what's going on before you come in, read those guides as well. Speak to the other side, see what you can come up with as a resolution. And when I say partial resolution, that might even be, agreeing on an order of the parties, agreeing on documents. You have different piles of documents you have to use. Well, why don't we just put it all in one brief with tabs that go from 1 to 10. You have 5 documents, I have 5 documents. Being able to come to those small little organization decisions makes a big difference when you're in court. It makes you look like you're organized. It's easier for you. And that way you can either defend your case or be able to pursue your case a lot more effectively. When you're preparing those materials, to have them organized, to have copies for everybody, especially documents. If you're going to be showing photographs, to be able to have clear copies of documents, of photographs. When we're talking evidence, we're talking either viva voce, the witnesses, what they say is evidence and answering the questions, but what you're entering as exhibits as well. So have those clear, have them organized, and so that it's easier and more convincing when you're in court. Preparing evidence in support of your position and being really familiar with that is going to help you out, above and beyond what you would normally do to prepare for a meeting. You need to know who the witnesses are going to be, anticipate what they're going to say. Your witnesses, meet, ask questions, being able to understand what the story is and what people are going to say as your own witnesses, and reading the documentary evidence. Read every line. Read all of the details. You may have looked at it months and months ago, especially if you're a defendant and it's something that you're not that familiar with. Reading all those emails, reading all the photographs. And this is something that in preparation for trial is very important to be able to deal with. If it's a motion and there's an affidavit, because it's not live witnesses at a motion, it's affidavits, then read the affidavit, read it backwards, read the pleadings backwards, look at something in a different way so that you're familiar with what it actually says and not just what you think that it says when you read through. Preparing your oral arguments in your submissions to the court are also very important. Lawyers, paralegals, we practice, we go to school, we do this every day. It's part of our practice, it's part of our vocation. You likely don't argue a position in that same way very often. And so prepare what you're going to say, read it out loud. That doesn't mean that you have to follow a script, but to be able to hear yourself being able to say it in a very convincing, organized fashion, but at the same time not being too emotional and not going overboard with what it is that you're going to say, but just presenting your case in the way that you think that it should be decided is important. But preparing for that is also important. Take a lot of notes. If you're not familiar with computers, write it down, write notes, write it point form if you don't want to write it out in sentences. And these are some of the tips, certainly for preparation, that I recommend. In a trial, the plaintiff goes first, their witnesses, and so you will make your oral submissions. The defendants has their options on making their oral submissions, their introduction to the case. And then as a plaintiff, you have a witness that is going to present that evidence, and then that witness gets cross-examined from the defense. And then you get a chance of reply on that evidence. And that works out for all of the plaintiff's witnesses. And after the witnesses are finished for the plaintiff, the defendant or the defendants, one at a time, will present their witnesses. Questions will be asked the same way in direct examinations, open questions, and then cross, which is direct questioning, and then a right of reply, and all of the witnesses go through that, and then there's closing submissions. It's very similar in a motion. A motion, you have the affidavits, you don't have live witnesses. There's moving party makes the argument, the defense or the replying party makes their arguments, and then there's a right of reply. And so that you kind of understand, again, reading the rules and the guide on how that works out while you're there. Speaking of that evidence and those exhibits, if you are self-represented and you are the only witness or you are the witness, you're going to make your oral arguments as the plaintiff. And then after you will be the witness, you will be either sworn or you will affirm to tell the truth by the court clerk. And then you will sit in the witness box. So you won't, sometimes you will stay at counsel table, but normally you'd be sworn and then you'll be able to sit in the witness box. And then you'll be able to tell your story. Now, remember that it should be very factual as you present your story. Being able to use dates is also very useful, or days of the week or periods of time if you don't know the exact weeks. Focusing on the events or the facts that are necessary to make your case, and not a lot of the color that goes around it, which is in most circumstances irrelevant. Rely on documents. You have emails in your brief, or you have an invoice, or you have a report or photographs, to be very matter of fact about what you're presenting. And to follow up, just a very matter of fact, if you have documents, use the documents. It's very convincing when something that you're saying can be backed up in a document, an email, a correspondence, an invoice, or a photograph. And not to forget about that if you're being a witness yourself without being asked questions. If you're the one examining, remember that you, in examination chief of your witnesses, you ask open questions. You ask those questions one at a time. The witness answers one at a time. And same thing for cross-examination. One question, one answer. One question, one answer. When in cross-examination, another party asks witnesses questions in order to just challenge the evidence that's presented, establish points of fact. It's possible that some witnesses say something that everybody agrees on. It's often just a few facts that people don't agree on. So use all of your witnesses and be able to get the evidence that you need from all of them. There's always a re-examination of witnesses after they've been crossed. And so if something is happening in cross-examination and you'd like to clarify something, it wasn't something that was brought up earlier, then know that you have that right to be able to cross-examine. It's an opportunity to clarify and to address those points being raised during that cross-examination. Often people are objecting to cross-examination when they shouldn't, and they should be waiting for reply, or when you have that right to be able to do that. You can't raise new points in reply. You can just address what was being brought up in cross-examination. And know that exhibits can be a variety of things. Like I said, oral testimony is evidence, but an exhibit can be a photograph, it can be a video, it can be a map, it can be a survey, it can be a letter. So think of the different aspects that can support your case, and you can use that. For oral submissions, so after the evidence, after the witnesses are finished and you're doing your submissions at the end of your trial, my number one tip would be to use notes. It's really important to follow a script, plan ahead of time what you're going to say. It's possible after that the evidence has been heard, you could tweak that a little bit, but this is something that you should prepare ahead of time on what are the facts that support your case, what's the law that supports your case, or the reasoning, why the law is really like, why should I be winning, why should I get what I'm asking for, and the facts are what happened, and then in comparison to why it is that I have a right to have what it is that I'm asking for. It's really the time that you get to do your arguments. Until the closing submissions, you shouldn't be arguing about your position, about your relief. It should be very factual until then. If a judge asks you to focus on one aspect of a problem, you should just address that issue. You want to be addressing what the judge is questioning, because you are trying to convince them to be able to rule in your favor. If they're inquiring about a certain area, go right away to that area, skip over what you had planned and address that question or address that issue. Be courteous, of course. Even if you don't agree with what the judge is saying or the comments, it's possible that they're playing devil's advocate a little bit and want to hear you on a certain point. You shouldn't read into questions that the court is asking. They're just trying to fulfill their role. If they ask a question, and you don't understand, ask for clarification and be able to understand the question, but address the point very clearly. Explain your position with facts, use facts that aren't debatable, and that's the best way. Dates, for example, or documents. Use what the witnesses have said, use the documents in your submissions as well. If you don't know the answer to a legal question, you could ask some time, a quick adjournment to be able to look at that. Again, if you don't understand something that's happening, ask for clarification. You have a right to do so. Lawyers, paralegals, we all do that. So certainly understand questions. And avoiding repeating the same evidence and the same arguments. You're usually on a certain amount of timetable, and it's a lot more convincing if you're just touching on something once. At times, after the trial and after you've done submissions, a judge is going to deliver their decisions from the bench, we say, so live right away. While a judge is delivering a decision, again, with respect to court decorum and etiquette, take your time to breathe and to listen to the decision, but you shouldn't have a big reaction. You should be able to listen to that without shouting in celebration or without being able to interrupt the judge. It's very inappropriate. And so most of the time we receive decisions in writing, and it takes quite a while, a few weeks or maybe a few months to get a decision, but it does happen that decisions are from the bench, and so you should remain neutral while the decision is being rendered by the court. Now, there are bilingual proceedings. Section 126 from the Courts of Justice Act entitles parties that proceeding be conducted as bilingual proceedings. So it could be requested only in designated bilingual areas, but here in Ottawa, we are a bilingual area. And so there's a few methods by the regulation that allows you to be able to alert the court that it's a bilingual proceedings. So if the plaintiff's claim is in French, that's one of the methods, or a defense, that's one of the methods that the court is alerted to a bilingual proceeding. You can file a requisition, it's a form just to advise the court as well. You can make that statement to the court. So if you were at a motion or if you were at a settlement conference, more appropriately, you could inform the court that it's going to be a bilingual proceeding, and therefore the matter would become a bilingual proceeding. Also, you can write to the court and request it to them. And those are the ways that you can communicate to the court and flag to them that it's going to be a bilingual proceeding. If it's a bilingual proceeding and you're going to require interpretation, you have to request services as soon as you realize they're necessary. If you need interpretation services, contact the court interpretation unit at the courthouse where the case is going to be heard, and so depending on the jurisdiction of your small claims matter. When you request the services, you have to have information about your matter to let them know the language of interpretation, who's requesting it, why, what's the date, where's the hearing for. Provide that information, and then you'll be able to set up translation services for you. Now, with respect to in-person hearings, if you do have in-person hearings and you have to go to the courthouse, There's of course precautions that are in place to address the risk associated to COVID in this health crisis. Before you enter the courthouse, you have to complete an online questionnaire. It has to show, you also have to have proof of that questionnaire when you're coming and being admitted into the courthouse, either on your smartphone, or you can bring a photocopy as well, but that's a requirement prior to you entering. The wearing of a mask is mandatory when you enter the courthouse. And there's also indicators throughout the courthouse, either on the floor or in sections on where to wait in line, certainly respecting the 2 meters apart and going through the courthouse security. There's certain limitations with respect to elevators, arrows, directional arrows, seating, and even a maximum number of people in a courthouse, a courtroom particularly. So to be able to respect that prior to you attending and knowing what you need prior to getting there so that you're well prepared. Now, arriving at the courthouse, you have to go through security when you go to a courthouse, and you have to keep a couple points in mind when you're going through security, again, so that you're not late for your matter, but of course, so that as you're going forward, that you'll be able to properly prepare. You have to go through a metal detector, purses, backpacks, all of that's going to be x-rayed. Anything that's considered to be dangerous or to be a weapon, of course, is not allowed in the courthouse. If you're in possession of an item that security may not think is appropriate or dangerous, they can ask you to leave it. But when you come back, that item's not going to be there for you. And so you might not be able to retrieve it, likely not. And so it's important for you to know that when you're coming with everything to come to the courtroom. Examples that I can give, if you have a pocket knife or knives or other manicure kits, often nail clippers, scissors like that, things that you'd have in your bag, it's possible that you're not going to be able to go through with those items when you come into the courthouse, and so not to have those if you have a backpack or a bag with you or a purse. You can't bring any flammable items with you, certainly no firearms or ammunition, but alcohol, any kind of inflammable materials as well. So just be aware of that when you're coming through the courtroom. You have to go through security, and you may bump into either the other parties and such, and so just be wary of that. Usually the public space in the courtroom is open, and so try to be as comfortable as possible. Again, if you want to come with somebody to the courtroom, you certainly can, and ask permission for that during these special times to see if that's possible for that person to be with you. Now, as discussed a little earlier on, we have here a list of resources that I recommend that you follow up on. If you're preparing for a matter or preparing for a certain proceeding, they'll provide you with some information. There's a lot of guides there, certainly a lot of information in both official languages for you. Etiquette, Ontario Legal Information Center, National Self-Represented Litigants Project, Pro Bono Ontario, Legal Aid Ontario, the Law Society of Ontario Referral Services if you're looking for an inquiry. As discussed, small claims court guides in information, I certainly recommend that. The Ministry of Attorney General has done a great job in preparing those materials. CLIO and Steps to Justice Small Claims Court is also something that I recommend.